Introduction to the United States Legal System. This presentation will highlight some key points about the U.S. legal system. The slide shows the buildings that house the United States Supreme Court in Washington, D.C., and the Florida Supreme Court in Tallahassee. The two Supreme Courts are indicative of the dual court system in the United States. The U.S. has a federal and a state court system. Both systems have trial, appellate, and Supreme Courts. The U.S. Supreme Court is the highest court for both court systems. State courts have broad jurisdiction, so the cases individual citizens are most likely to be involved in, such as robberies, traffic violations, broken contracts, and family disputes, are usually tried in state courts. The only cases state courts are not allowed to hear are lawsuits against the United States and those involving certain specific federal laws, such as federal criminal law, antitrust, bankruptcy, patent, copyright, and some maritime cases. Federal court jurisdiction, by contrast, is limited to the types of cases listed in the Constitution and specifically provided for by Congress. Federal and state court cases, the numbers. Let's examine the differences in the caseloads between federal and state courts. State courts handle a much larger number of cases and have more contact with the public than federal courts do. The upper pie chart shows 30 million state case filings annually compared to 1 million federal case filings. The lower pie chart shows the vast majority of federal court cases are bankruptcy filings. 30% of the filings are civil or criminal cases. Of that 30%, 20 are civil and 10 are criminal. The federal court system has 3 tiers. The lowest and the largest tier includes the 94 district courts and other trial courts, such as the U.S. bankruptcy courts. The intermediate appellate level includes 13 circuit courts of appeal. 12 of these courts are regional circuits. The regional circuits include 11 numbered circuits and the D.C. Circuit. There is also the Federal Circuit Court of Appeals. Finally, the highest court is, of course, the United States Supreme Court. And as you all know, there is only one of those. United States Federal Court Map. To find the relevant district court or federal circuit court, it is best to consult a map. For our purposes, we will note that the state of Florida is within the jurisdiction of the 11th Circuit Court of Appeals, as are the states of Alabama and Georgia. The states in the 11th Circuit Court of Appeals were originally part of the 5th Circuit, but they were split off to form the 11th Circuit in 1981. So you may find older cases involving Florida under the rulings of the 5th Circuit. Florida Federal District Courts. Florida has 3 district courts, one for the Northern District, one for the Middle District, and one for the Southern District. The Northern and Southern District Courts were created in 1847. The Middle District Court was created in 1962 from parts of the Northern and Southern Districts. The courthouses for the Northern District are located in the Florida court system. The Florida court system has 4 tiers. There are 2 sets of trial courts in Florida, the circuit courts and the county courts. The circuit court also hears appeals from the county court. Thus, the circuit court is both a trial and an appellate court. There are 5 district courts of appeal that serve as intermediate appellate courts. Finally, there is the Florida Supreme Court, which is the state court of last resort. Florida court jurisdiction. It is important to understand the dual trial court structure in the Florida court system. Each Florida county has a county court that can hear misdemeanors, small claims up to $5,000, civil claims up to and including $15,000, and traffic matters. Florida circuit courts serve one or more counties and can hear matters involving felonies, family law matters, civil cases over $15,000, probate, guardianship, mental health, juvenile dependency, and delinquency. Florida District Courts of Appeal. There are 5 district courts of appeal in Florida, located respectively in Tallahassee, Lakeland, Miami, West Palm Beach, and Daytona Beach. Florida did not have district courts of appeal until 1957. The bulk of trial court decisions that are appealed are never heard by the Florida Supreme Court. Rather, they are reviewed by 3 judge panels of the district courts of appeal. As a general rule, decisions of the district courts of appeal represent the final appellate review of litigated cases. A person who is displeased with a district court's express decision may ask for review in the Florida Supreme Court and then in the United States Supreme Court, but neither tribunal is required to accept the case for further review. Most are denied. You should also note that each district court of appeal has jurisdiction for 2 or more circuit courts in Florida. The Florida Circuit Courts. This is a jurisdictional map of the 20 circuit courts in Florida. The Constitution provides that a circuit court shall be established to serve each judicial circuit created by the legislature, of which there are 20. Until the 1970s, Florida had more different kinds of trial courts than any state except New York. A movement developed in the late 1960s to reform this confusing system. As a result, Florida now has a simple 2-tier trial court system. The majority of jury trials in Florida take place before one judge, sitting as judge of the circuit court. The circuit courts are sometimes referred to as courts of general jurisdiction. Florida County Courts. This is a jurisdictional map of the Florida County Courts, which is basically a map of all of the Florida counties. The Constitution establishes a county court in each of Florida's 67 counties. The trial jurisdiction of county courts is established by statute. The majority of non-jury trials in Florida take place before one judge sitting as judge of the county court. The county courts are sometimes referred to as the People's Court, probably because a large part of the court's work involves voluminous citizen disputes such as traffic offenses, less serious criminal matters, misdemeanors, and relatively small monetary disputes. Florida Court Filings. Circuit and County Court Filings by Circuit, fiscal year 2012 to 13. This chart shows that the majority of court filings in Florida take place in county courts. Notice that the 11th Circuit, serving Miami-Dade County, the 17th Circuit, serving Broward County, and the 15th Circuit, serving Palm Beach County, have the highest numbers of court filings in the state during this fiscal year. As you will note by the box above this chart, the total county filings are over 3 million, while the circuit filings are 877,883. As you can see, the county court filings are much greater than the circuit court filings in any given year. Florida Circuit Court filings. Circuit Court filings by division, fiscal year 2012 to 2013. The majority of circuit court filings involve civil cases, 33.5%, and family cases, 33%. Criminal cases comprised 21.3%, while probate cases were 12.2%. Florida County Court filings by division, fiscal year 2012 to 13. In county court, the vast majority of filings are civil matters, 76.3%. The remaining 23.7% are criminal matters. Court confusion. Courts with similar names. Some courts have very similar names, so it is important not to confuse them. For example, when referring to the district court in Florida, don't confuse the United States District Court with the Florida District Court of Appeals. Most lawyers in Florida call the District Court of Appeals the DCA. In addition, make sure that you do not confuse the U.S. Circuit Court of Appeals with the Florida Circuit Court. To add to the confusion, both courts are referenced by their circuit numbers. So make sure you know which one is being referenced. For example, refer to the United States Circuit Court as the Circuit Court of Appeals. This concludes the presentation on the U.S. legal system.